Hello, I'm Ken Harrell, and I'm the managing partner of the Joy Law Firm in South Carolina. Our workers' compensation system was designed as a no-fault system, which involved a lot of trade-offs between generally making the employer automatically responsible for your workers' compensation benefits when a worker is injured on the job, but also placing tight caps on what can and can't be recovered by the injured worker. By way of an example, there is no recovery under the South Carolina workers' compensation system for intangible damages such as pain and suffering and loss of enjoyment of life. However, there are some benefits under the workers' compensation system which are more beneficial to injured workers than what likely would be recovered if they had sustained the same injury in an automobile accident. And the most important one of these benefits is the possibility of an injured worker being able to receive future medical coverage for his or her work injuries. If you compare that to an automobile accident injuries claim, what happens in those cases is that one amount is paid to the person who was injured in the accident due to the fault of another. Once that payment has been made, either pursuant to a release or perhaps as a result of a jury verdict, that's the end of the case. The person who has been injured cannot come back and ask for a supplemental recovery if, for example, 2 years after the settlement they need another surgery on the body part they injured in the automobile accident. That is not necessarily the case with a workers' compensation claim. For a work-related injury, our law allows the injured worker to protect future medical needs as long as certain requirements are met. For many injuries that we see sustained by workers, such as ones involving back surgeries or knee surgeries, it's a given that the person is going to continue to have some fairly significant treatment needs long after a settlement. Perhaps the injured worker will need ongoing pain management treatment. Perhaps the injured worker has hardware in their body as a result of a fusion surgery. They may even have an artificial joint, such as an artificial shoulder or an artificial knee. If that's the case, it's extremely important that the injured worker protect his or her future medical rights. One problem with the injured worker's ability to do this is that changes made to our workers' compensation laws in 2007 made it much more difficult for an injured worker to protect his or her future medical needs unless they have an experienced attorney assessing them. In fact, I don't see how an injured worker can protect future medical rights under our workers' compensation system without the assistance of an experienced workers' compensation lawyer. Why is that the case? Let me give you just a few examples. Based on changes to our law in South Carolina, no future medical treatment can be awarded now unless a doctor has stated that the medical treatment will be necessary to a reasonable degree of medical certainty. And that phrase, to a reasonable degree of medical certainty, has become a very important part of our workers' compensation law now. If you don't get the doctor to state his or her opinion about future medical needs using that phrase, that would prevent the Commission from awarding future medical treatment. And I would submit to you that most workers' compensation doctors don't even know that they're required to use this language. And of course, hardly any injured worker is going to know that this is a requirement. Another problem is that with Form 16 settlements in South Carolina workers' compensation cases, and this is the settlement method that's typically used for unrepresented workers, no further medical treatment is allowed unless the settlement agreement specifically provides for the type of medical treatment that the injured employee would be able to receive. If the case is tried in front of a workers' compensation commissioner, the law now requires that the commissioner award any future medical treatment with specificity. There's also now a potential trapdoor in our law that a number of unrepresented workers are going to fall through. As the law is now stated, if there is a 1-year lapse in the injured employee's medical treatment for their work-related injury, that will now void any future medical coverage unless the settlement or the Commission's order states otherwise. The bottom line is that in order for an injured worker to protect himself or herself when it comes to future medical needs, you will almost certainly need to have experienced legal assistance. If you would like to receive more information about our law firm and our workers' compensation department, please visit our website at www.joylawfirm.com. You should also feel free to give us a call and understand that there is never a charge for talking to us about your case. If you decide to hire us to represent you on your workers' compensation claim, we only work on these cases on a contingent fee basis, which means that we're only paid if we obtain a recovery for you. You can call our law firm and speak with one of our workers' compensation attorneys by calling 888-324-3100. Finally, please feel free to email me directly at kharrell@joylawfirm.com. I hope the information in this video has been helpful to you. Again, if you've been injured on the job in South Carolina and you know you're going to have significant future treatment needs, I urge you to hire an experienced workers' compensation attorney, wherever you decide to hire our law firm or someone else. Thank you.